Hi, Max here at FrizWoods, and in this video, I'm going to be talking about the crime of second-degree assault in Maryland. I'm going to talk about the legal definition, some of the different ways that the state can try to prove the case, some of the more common defenses, and a few things that you can do ahead of court to help yourself out. Get prepared. All right, let's jump right into it. What is a second-degree assault in Maryland? Well, the first thing you should probably do is look at the statute, and the statute helps us out by saying committing an assault is prohibited. What does that mean? Well, we're going to then have to look at some of the case law, jury instructions, and things like that to understand the different theories that a state can prove an assault, because that definition gives us very little help. First and foremost, we generally break down three different ways that the state can prove a second-degree assault. I'll talk about each one individually. First and foremost is the most common one, the one that everyone probably thinks of, and that is what we refer to as a battery. Now, there is no crime of battery in Maryland, but the state could prove a second-degree assault through a theory of battery. What I'm talking about here is flick of the ear, punch in the face. You get the idea. If you touch somebody in an unconsented way and it causes some sort of injury, then that might be considered a battery. Now, bear in mind, physical injury is not a requirement of assault here, so you don't need to leave a mark to have committed an assault. And I have represented people in cases where the allegation is a battery that left no mark, and the state has proceeded in those cases before. So we have a battery, and then we have the next theory, attempted battery. Okay, attempted battery I'd like you to think of as a swing and a miss. Okay, the state's got a video of you inside of a CVS, and you swung on the cashier but didn't hit them. That is not a defense, because attempted battery is treated the same as battery for the purposes of evaluating whether or not somebody has committed a second-degree assault. The last and final way is a little bit more unique. Here we're talking about intent to frighten. So you might be, if you're the defendant, you might be holding a knife menacingly. And believe it or not, that could also be considered a second-degree assault here in Maryland. So those are the three different ways that the state can prove it, bearing in mind the state has to prove beyond a reasonable doubt that an assault occurred. Let's talk a little bit about what the maximum penalty is. You're looking at a possibility of up to 10 years of incarceration. And that seems crazy to a lot of people, and it may just be. But here in Maryland, we have a two-tiered assault statute, meaning a misdemeanor assault carries a maximum penalty of 10 years and $2,500 fine. That's the lower tier. The next step up is a felony assault. That's a 20-year felony, and that carries a maximum penalty, 20 years, like I said. But the difference is sometimes minimal here. So everything from that flick of the ear to the meanest left hook you can throw is considered a second-degree assault and faces the same maximum penalty. What that means in practice is that a practicing criminal defense attorney will tell you they've seen probationary, fully suspended, no jail time sentences on second-degree assault. They've seen judges strike convictions and give out probations before judgment. On the other hand, they've seen clients get years in prison in the Department of Corrections for assault in the second degree. So this giant maximum penalty leads for a wide range of potential sentences. It also leaves a lot of people troubled, because when you receive a criminal charge for flicking your neighbor's ear and it says you can get 10 years in prison for it, well, you're probably pretty confused. Here in Maryland, though, like I said, we only have 2 degrees of assault. So there's felony assault and second-degree assault. There is no third or fourth degree, and perhaps there should be, but that's probably a conversation for another video. That first-degree assault felony is typically charged alongside second-degree assault in cases involving strangulation, a firearm, or an intent to cause a serious bodily injury, shooting, stabbing, a real beatdown. You get the idea. Now, I've told you about what can make a second-degree assault. I've told you about the maximum penalty. And next I said I was going to talk about some of the potential defenses to second-degree assault. If you look down below right now, I'm going to link my last video, which is on self-defense, which it deserves a video of its own, frankly. Self-defense needs to be generated during a trial. And you can watch a video below and learn more about how it works here in Maryland. Some of the other common defenses might include mistaken identity. Police have a still of a man punching a store clerk at Wawa, and they identified you as the person based on your MVA photo or something. You live in the neighborhood, you get the idea. You may have been mistakenly identified, and the identification procedure might be flawed, and that might be something we can attack in court. Another common defense to second-degree assault might be an alibi. In 2024, everyone's got a phone that knows exactly where they are. They also take a lot of photos of almost everything they do. So, if you've got a photo of yourself at Texas Roadhouse when this assault supposedly occurred at the CVS or Wawa, then perhaps you have a good alibi defense, which is another common defense we see. Now, second degree assaults come in two varieties. We have domestic and non domestic. In a domestic assault, things are a little bit different. Although the maximum penalty is the same, this involves a loved one, someone you have children with, someone you're in a relationship with, or a family member. And in those cases, mistaken identity might not necessarily be the best defense. But sometimes, when self defense doesn't play a factor, we see consent as a defense often in assaults, but especially in domestic assaults. Now, consent in a traditional assault might be the old meet me out in the parking lot, and you go meet that person out in the parking lot, you get the better hand. Well, they consented because they asked you to meet them in the parking lot. In a context of a domestic assault, the other person may have hit you first. They may even admit to that, and you may have hit them back. They may have said something along the lines of hit me, which I'm not surprised to say I've seen before in videos in criminal cases. Putting that aside, domestic assaults also raise additional challenges related to bail and other things. So I've talked a little bit about the offense of second degree assault, the maximum penalty, the different ways the state can prove it, and then I talked about some common defenses, and I'll close with some things you can do ahead of court to sort of help yourselves out. First of all, speak with a qualified criminal defense attorney or apply for the public defender. Nobody should walk into a court and try a second degree assault as their first case because they think that they can do a better job than a lawyer. A lawyer's going to know a lot of the law I talked about and probably even more. Every case is unique. Your best defense is probably not in this video. Your best defense might be something else. So it's important to speak with a qualified criminal defense attorney and they'll help you develop a tailored defense strategy for your case. Okay, I get it. Hire a lawyer. What else can I do? Well, a lot of the times I recommend for my client many of the things that they might be ordered to do if they were placed on a probation. So here we're talking about anger management, if it's in the context of a stranger assault. Or perhaps if it's domestic, I might ask them to enroll themselves in the abuser intervention program. Bear in mind, these things should not be held against you in court. These are things you're doing ahead of court to sort of put yourself in a better position, both bargaining and potential sentencing. If you have a drug or an alcohol problem, or there's the appearances of one because you were drunk or high at the time of this alleged incident, then perhaps you want to engage in a treatment course. Get treatment or education course that tests you, and you can show a court that you have not been using recently, and that may in fact be the deciding factor in whether or not you receive jail time in your case. So I've talked a lot about different things that you can do ahead of court, and every case is different. But if you've reached this page, that's because you're trying to learn more about your charges and trying to put yourself in the best position possible. If you've got a case here in Maryland, we are a Maryland-based criminal defense firm. We are happy to help you. We have a 24-hour attorney line you can call anytime because almost nothing happens between 9 and 5. If you want to give us a call and have a confidential attorney-client privilege, we'd be happy to talk about your case with you. So please give us a call. We're here to help. Good luck.